Of my colleagues ask you about the Supreme Court overturning precedent. Now, it doesn't happen every other Thursday, but it's not what's the word I'm searching for, Judge? It's not extraordinary that the Supreme Court overturns precedent, is it? I mean, it happens. I won't say a lot, but it's not once every 50 years. Am I correct?
You're correct that it's more frequent than once every 50 years, for sure. Yes.
And so it happens.
Yes.
And you talked earlier briefly about the different factors that the court considers.
Yes.
In deciding. Give me a couple of those. Hit that another lick for me and just give me a couple.
Whether the decision is egregiously wrong, whether there's been reliance on the decision that is being revisited, whether the decision is workable or unworkable, the one that they're looking at, whether the facts are new facts have come to light, or the facts have the circumstances are such that there's now a new understanding of the prior facts, and whether the case law in the area has shifted.
And in fact, those are the factors that the Supreme Court listed 3 years ago in Janus, are they not?
Those are the factors. I don't have the Janus opinion in front of me, but those are the factors that the court uses when it determines.
Janus overruled, I think Senator Hirono talked about it. Janus overruled Abood.
Yes. Dealing
with whether labor unions can require non-members to pay dues. Remember that case?
Yes.
Is the age of the case, a factor in whether the Supreme Court will overrule a precedent?
I think age relates to the reliance factor. I think the longer an opinion has been in effect, the court has considered that to be relevant to its determination of reliance.
But sometimes the court looks at it not just in terms of reliance, they look at it from the other side of the age issue, and that is that maybe facts and circumstances and science have changed. Do they not?
I believe that is part of the changed circumstances factor.
So the Supreme Court is more likely to overturn a case, which would not be that extraordinary, if the precedent were 49 years old as opposed to 4.9 years old.
I'm sorry. Can you repeat the question?
Yeah.
I'm just
well. You said that the older the case is, one could make an argument that the reliance interest would be great. But you also said, I think, I don't mean to put words in your mouth, but the older the case is, the more facts and circumstances and science could have changed. So that would argue in favor of overruling it because of a change of circumstances. Did I get that?
It might. These are all different circumstances that the court could consider under this multi-factor test.
Okay. But all things being equal, let's say a decision 49 years old versus 3 years old, like Janus. The older decision is more likely to be overturned, you think, based on your experience?
Oh, I don't know that I could make that prediction. I'm just saying that one of the factors, the reliance factor, the age of the opinion and how long people have been relying on it.
Yes, ma'am.
Can be relevant to, it is one of the factors that the court considers.
Right. Okay. Let me jump gears here. I took some notes. You talked earlier about how you decide cases. I'm going to kind of summarize this. You said you clear your mind of any bias. You read everything. You read the briefs and the record, and then you apply the law. That's your methodology. You said you're not an activist judge. You said, am I right?
Yes.
You said judges are not politicians.
That is true.
And judges should stay in their lane.
Yes, sir.
Tell me again what you mean by stay in your lane.
What I mean is that in our system of government under the Constitution, we have a separation of powers, and each branch has their own sphere of responsibility. To say stay in your lane is the shorthand that I'm using for indicating that judges should not be policymakers, that those responsibilities are left to the elected branches, and that judges are to interpret the law, not make the law. And I use it to refer to the part of my methodology that is mindful of the constraints on judicial authority.
Okay. Well put. So let me ask you. We can go to the Constitution, let's say the Bill of Rights, to narrow the discussion, and read about our explicit rights. Mm-hmm. Religious freedom, our right not to be unreasonably searched or seized, freedom of speech, they're right there. Mm-hmm. That's why they call them explicit. But the court has ruled we have a bunch of unenumerated rights. Am I correct?
The court has determined there are certain personal rights related to individual autonomy that are implicit in the concept of ordered liberty or deeply rooted in our nation's history or tradition.
But they're unenumerated?
Yes.
Okay. Should these unenumerated rights that only Supreme Court justices can see, should they be decided by the people through their elected representatives or by the unelected federal judiciary?
Well, Senator, the Supreme Court has interpreted the 14th Amendment to have a substantive component, and I'm not in a position to critique the court in terms of its precedents. That is the precedent of the Supreme Court.
Right, right. Well, let me ask you this: what is a fundamental right?
The court has interpreted the 14th Amendment's due process clause to include a substantive component and not just a procedural component, meaning the 14th Amendment guarantees due process, and the court has interpreted it to mean that with respect to certain rights, individual rights concerning intimacy, certain things like the right to contraception, the right to child rearing. There was a case of the Supreme Court that talked about making decisions for children in terms of visitation with respect to conflicts with grandparents, marriage.
Right. I'm with you.
These sorts of rights, the court has found, are implicit in ordered liberty, as I said, or deeply rooted in our nation's history and tradition.
The right to assisted suicide, is that one of those enumerated or unenumerated rights?
I believe the court found that it was not.
Okay. Which body do you think is better able to make that decision, the Congress or the federal judiciary?
Well, Senator, the Supreme Court has interpreted the Constitution, and the Supreme Court has the authority under our constitutional system to interpret the law.
Right.
And they've made the determination that the Constitution includes those unenumerated rights.
Yeah, but here's the thing, Judge. Maybe a better example, it's a very hot topic today, the right of a transgender woman to compete in women's sports. Do you think Congress, the people ought to get to decide that through Congress, or the judge can just find it as an unenumerated right, a penumbra of the Constitution?
Well, Senator, that the topic that you raised is something that is, as you say, a hot topic today, and could certainly be litigated. So I'm not in a position to say more about whether or not it's actually one of the unenumerated rights.
Well, I don't want to ask you how you'd rule, but would you have any problem saying, okay, if that case that is litigated, saying this is a political question? Whoa, stop! I'm staying in my lane. Congress needs to decide this case. The people need to decide that through their elected representatives. Well, would that be appropriate?
Well, respectfully, Senator, that is a decision. In other words, you say, I'm not asking you to decide it, but in every case, the determination about whether or not something is a political question or whether or not the court has or has not jurisdiction is an issue for judges, and so I'm not able to speak to it.
Okay. All right. Well, here's the thing about the fundamental rights. That's why I asked you about the definition of them. These are unenumerated rights now. I'm not talking about right to free speech and freedom of religion. The court has said repeatedly that there is no test for a unenumerated fundamental right, that the determination has not been reduced to a formula. Am I right?
Well, they've given those standards in the cases in which they have been evaluated.
In some cases. Sometimes the court talks about these unenumerated fundamental rights have to be deeply rooted in the nation's history and traditions. Sometimes the court says, they change the language, these unenumerated rights, like the right to assisted suicide we talked about, it's a potential unenumerated right. The right has to be implicit in the concept of ordered liberty. But you've read Obergefell. In Obergefell, I think Justice Kennedy wrote that opinion. He didn't bite. In fact, he cited with approval Justice Harlan's dissent in Poe v. Ullman. And Justice Harlan said, look, there's no formula here. Justice Harlan always said, you have to go case by case. Can you understand why some Americans go, wait a minute, are justices, these are unenumerated rights, are justices interpreting the Constitution, or are they just deciding a right when they get 5 votes, and it's just a moral conviction?
Yes, Senator, I do understand.
Okay. Well, when you talk about judicial restraint, where does the restraint start with fundamental rights? Let's take the 9th Amendment, okay? What's it say? I know you know because you talked about it earlier.
Well, it says that it indicates that there are rights that the fact that there are some enumerated rights in the Constitution doesn't mean that there aren't others.
And how are we supposed to determine what others there are?
I think the Supreme Court has not found any others coming from that particular constitutional provision.
Could they?
I can't speak to that, Senator.
I mean, it's possible, right? If they get 5 votes, right?
Well, anytime the Supreme Court has 5 votes, then they have a majority for whatever opinion they determine.
Yeah.